our program. I'm Rachel Pierce, and I'm joined today by my colleague, Krista Rubin. Welcome back, Krista.
Thank you. Thank you.
Today is the third in our series of interactive broadcasts that deal specifically with advanced guideline issues. And today's program is going to focus on immigration offenses. What we're going to do today is primarily focus on the illegal reentry guideline at 2L 1.2. We will later on in the broadcast, however, touch on the smuggling and harboring guideline at 2L 1.1. Now, our goal today is to provide you with a greater understanding of guideline application, specifically as it relates to immigration offenses. And we're going to be talking about analyses that need to be done for particular subsections of both 2L 1.2 and 2L 1.1. And in turn, how that analysis is going to impact some of the determinations that are made and how that in turn will affect the offense levels and ultimate sentence for defendants that are sentenced under these immigration guidelines. But before we get started with all of that, Krista, why don't you let our viewers know about some of the housekeeping items that they're going to need to be aware of today?
Sure. First, let me remind you that there are participant materials available for you on the DCN site, and the address is going to be showing up on the bottom of our screen. We have a copy of the slideshow that we're going to be using throughout the broadcast today. So if you haven't gotten a copy of that yet, you might want to do that. Also, please, we encourage you to fax in your questions while the broadcast is going on. As Rachel mentioned, we are going to be addressing particular analyses, and these real-life fact patterns and issues that you have will be wonderful for us to help move along through the analyses and give you guidance on advanced issues relating to immigration offenses. We also want to make note of the audience that we have today. Now, we understand that we've got a broad array of experience here. Some of you have been doing guidelines application for quite some time. Some of you who are watching today are newer to the process. We know, too, from some of the faxes we've already received that some of you have a caseload that is heavy with immigration offenses, while others of you are just now starting to deal with these particular types of crimes. So we are going to today try and give everybody a good overall view of how to calculate the immigration guidelines, both the illegal reentry guideline as well as the smuggling guideline. But as the title promises, we are going to be addressing advanced issues as well. So those will be peppered throughout the broadcast. And your faxes, of course, will help us greatly.
Also, just to remind you that we do have a helpline, and you'll see that number periodically through the course of the broadcast today. If there's any questions that we don't get to today, feel free to call us on our helpline, and we'll follow up with you and answer those questions as best we can. Let's go ahead and get started with our discussion of immigration today, and I want to talk a little bit about some statistics that you might find interesting. Over the past decade, the number of immigration offenses sentenced in the federal courts has more than quintupled. In fiscal year 1994, there was a total of 2,338 immigration offenses that were sentenced under the federal sentencing guidelines, comprising 5.9% of all cases sentenced federally. Contrastly, in the fiscal year 2006, immigration offenses comprised 24.5% of all cases sentenced under the federal sentencing guidelines. And the illegal reentry guideline at 2L 1.2, which is what I talked about in the opening, we'll spend the majority of our time on today, continues to compose the majority of immigration offenses sentenced federally. In fact, data from our most recent fiscal year of 2006 indicates that 16.8% of all offenses sentenced under the guideline were calculated under this 2L 1.2 guideline. So having said that, let's take a look at the guideline at 2L 1.2. As I'm sure most of you know, the guideline at 2L 1.2 is for unlawfully entering or remaining in the United States. And the statutes of conviction that go to this guideline are 8 U.S.C. sections 1325, which deals with the improper entry of aliens into the country, and 1326, which deals with the reentry of previously removed aliens. And the statutory penalties for violations of 8 U.S.C. 1326, as you can see, vary. And they vary depending on prior convictions. If the defendant has no prior convictions, the defendant's facing a statutory maximum of 2 years. If the defendant has 1 prior felony conviction, that statutory maximum is going to increase to 10 years. And as you can see, if the defendant has a prior aggravated felony conviction, that statutory maximum is going to increase to 20 years. Now, I know that Krista mentioned that a lot of you have been dealing with this guideline for a number of years, and of course, those of you who have heard the term aggravated felony over and over and over again. So let's just stop here for a minute and take a look at what is an aggravated felony. Most of you are aware that the statute defines aggravated felony at 8 U.S.C. section 1101 A43. And at this statute, there is a laundry list of offenses that are considered to be aggravated felonies. Things such as rape, murder, the illicit trafficking of drugs or firearms, crimes of violence, certain theft offenses, etc. What I want to point out here is that it's very important to remember that in the application of 2L1.2, the only time we need to be concerned about the statutory definition of aggravated felony is for the 8-level increase at 2L1.2 B1C. So it follows that the statutory definition of aggravated felony has no impact on increases that might be given under 2L1.2 B1A, B, or D. In other words, it's possible that a defendant could get a 16-level increase for a prior conviction that is not actually an aggravated felony. And we will talk, Krista will talk a lot more about that in depth later on in our broadcast.
And Rachel, you've already mentioned the level, so I think what we need to do now is just take a moment and look at the guideline itself so that everybody's familiar with the 16-level increase, the 12-level increase, etc. The guideline for unlawfully entering or remaining in the United States provides a base offense level of 8. The first specific offense characteristic, which would apply after the defendant was deported or unlawfully remained in the U.S. after a conviction for a felony that is of a particular type. This 16-level increase provides a laundry list of drug trafficking offenses with sentence imposed of greater than 13 months, crimes of violence, child pornography, etc. For the types of prior convictions listed here at B1A, the guideline provides the definition for these terms. As Rachel was just talking about the aggravated felony definition, it does not have any bearing on the 16-level increase here. So the definitions for these types of convictions are found in the guideline itself. Moving on through the guideline, there are other specific offense characteristics. A 12-level increase for a felony drug trafficking offense for which the sentence imposed was 13 months or less. There's the conviction for an aggravated felony under subsection C, which is an 8-level increase, and 2 4-level increases, a conviction for any other felony or for 3 or more convictions for misdemeanors that are crimes of violence or drug trafficking offenses. Now, looking at this guideline and listening to Rachel talk about aggravated felonies, it's evident that the definitions and the terms that are included in 2L1.2 are going to be very important to understand, and that really is where much of the analysis lies, is in how to define these particular terms. So Rachel, why don't we start talking about some of those terms now?
Sure, Krista. We'll start out by talking about we've talked a little bit already about the statutory definition of aggravated felony, and now we're going to talk a little bit about some of the guideline definitions that you're going to need to be aware of, and then we'll continue to talk about the interplay between these definitions and how important it is as you're trying to determine how to score these prior convictions. The guideline defines offenses in a general sense, and then it defines them in a more specific offense for certain types of offenses. Starting off generally and consistent with our criminal history rules, a felony offense is defined at 2L1.2, application note 2, as any federal, state, or local offense that's punishable by imprisonment exceeding 1 year. Now, the most important thing to remember about this particular definition is that it doesn't matter how the state or local jurisdiction may classify an offense, such that it may be classified as a misdemeanor in the state that it's in, but if it's punishable by imprisonment of a term exceeding 1 year, then it's going to be considered a felony for purposes of the guideline. And there are some states, such as Colorado and Massachusetts, that do provide statutory maximum penalties of 2 years for misdemeanor offenses. And again, we'll talk a little bit more about this in depth as we go on. But these are the types of offenses that, although considered misdemeanors in Colorado or Massachusetts, would be considered felonies because they're punishable by a term of imprisonment exceeding 1 year. On the other hand, the guideline defines misdemeanor at application note 4A as any federal, state, or local offense that's punishable by imprisonment of 1 year or less. So as you can see here, the kind of dividing line between the felony and the misdemeanor is whether it's punishable by a term exceeding 1 year or punishable by a term of 1 year or less. And again, those are kind of general definitions that are going to apply to all of your prior convictions that you're looking at. But then the guideline does go on to provide some more specific definitions for certain types of offenses. And as you can see here, we have a list of offenses at 2L 1.2b1a that the guideline does define: crime of violence, drug trafficking offense, firearms offenses, child pornography offenses, national security or terrorism offenses, human trafficking, and alien smuggling offenses. And Krista mentioned earlier that these are all going to be felony convictions that are going to be subject to a 16-level increase. I mentioned before that there are guideline definitions and there are statutory definitions, and we need to talk about the interplay between these definitions because it's crucial to understand that interplay when you're applying the guideline at 2L 1.2. But before we do that, I'd like Krista to walk us through some very important Supreme Court case law that aids the court in determining types of prior convictions.
It's evident from what we've already been talking about that the court is going to have to analyze first whether something is a felony conviction or a misdemeanor conviction, but then secondly, whether that prior conviction meets a particular definition under the illegal reentry guideline under 2L 1.2. There is an analysis that is called the categorical approach, and this was established by the Supreme Court. In 1990, in Taylor versus the United States, the Supreme Court first talked about this categorical approach analysis. Now, this case did not deal with illegal reentry in any fashion. This case dealt with whether a prior conviction would meet a particular definition under the Armed Career Criminal Statute. However, all circuits have held that this categorical approach analysis applies to the guidelines that look to prior convictions in calculating offense levels, illegal reentry, for example. Now, the Taylor case involved a prior conviction that the defendant went to trial for. And so in this trial case, what the Supreme Court said was for the prior conviction, the court must look to the fact of that prior conviction and the statutory elements of that prior conviction. And those two things were what the court needed to consider to see if this prior conviction met a particular definition for the purposes of the Armed Career Criminal Statute. Now, sometimes it may not be clear from the fact of the prior conviction and the statutory elements of that prior conviction just exactly whether that prior conviction meets a particular definition at issue. The Taylor court went on to say that sometimes the district courts will then need to look to other documents, other judicially noticed documents in order to make the determination about whether the prior conviction meets a particular definition. And the documents that were mentioned in the Taylor case are the charging papers and the jury instructions. And so Taylor first decided that issue, looking to the fact of the prior conviction, the statutory elements of that prior conviction, and if the court needs further clarification, judicially noticed documents such as the charging papers and the jury instructions. Now, the Supreme Court then clarified this Taylor decision in the Shepard case, which was decided in 2005. Now, in this particular case, the Supreme Court clarified that the district court can consider, of course, the fact of the prior conviction, the elements of the statute of which the defendant was previously convicted. But the court went on to say that for a guilty plea, the Shepard case involved a prior conviction that resulted from a plea of guilty and not from trial, as the Taylor court did. That the district courts, in making their determination of whether a prior conviction meets a particular definition, can look to the charging documents, any written plea agreements, the transcript of the plea colloquy, and any explicit factual findings that were made by the judge in the prior proceeding. So basically, judicially noticed documents are the only documents that the court can use to make this assessment. Under the categorical approach, let me also mention that looking to pre-sentence reports or police reports is not appropriate. The court is limited to just those documents that were mentioned in those Supreme Court cases. And there's plenty of circuit case law that further defines these Taylor and Shepard cases. So the bottom line is this. When we're looking at the illegal reentry guideline, the court needs to be very familiar with this categorical approach. It is going to come into play every time someone is sentenced under 2L1.2. In order to determine whether that prior conviction qualifies for a 16-level increase, for a 12-level increase, for an 8-level increase, the court will need to use the categorical approach to make that determination.
As you can see from Krista's discussion of the categorical approach, it's clearly a very important concept that courts need to be aware of. And they're going to be using the categorical approach to look at all types of prior convictions, especially crimes of violence and drug trafficking offenses. And we're going to talk about crime of violence and drug trafficking offenses separately. Those of you who have been dealing with the guideline at 2L1.2 for a number of years are probably already aware that the definition of crime of violence has probably generated the most litigation other than any other aspect of 2L1.2. So we'll go ahead and start off by looking at the definition of crime of violence. And again, this is a guideline definition that we're going to be talking about right now. And the guideline defines crime of violence at 2L1.2, application note 1B3. And it's really kind of a two-part definition, if you will. And the first part is a laundry list of offenses, if you will. There are certain enumerated offenses that the Commission has decided through the use of this application note are by definition crimes of violence. And as you can see, they include murder, manslaughter, kidnapping, burglary of a dwelling, forcible sex offenses, and the like. And again, the Commission has made the determination that if you have a list of offenses, or you have a prior conviction, that is on this list of enumerated offenses, it is by definition a crime of violence. And I would like to point out here for our viewers in the Fifth Circuit that if you're looking at a prior conviction and trying to determine if it's one of these enumerated offenses, that your circuit adopts what's called the common sense approach. And this common sense approach was first discussed in the immigration context in the Izaguirre-Flores case of 2005. So again, if you have a prior conviction, you're trying to determine if it's a crime of violence, first look to that list of enumerated offenses. And if it's not there as that list of enumerated offenses, you can move on to what is essentially the second part of the definition of crime of violence. And that is looking to the elements of that offense to see if they have any of those elements have as part of the statutory scheme the use, attempted use, or threatened use of physical force against the person of another. And this is typically where the categorical approach comes in probably most often. First looking at whether you have a prior conviction that is one of those enumerated offenses, and if not, looking to the statutory elements of the offense to determine whether or not you have the use, attempted use, or threatened use of physical force against the person of another, and therefore a crime of violence. Now, this appears, when you talk about it on the face, to be a pretty straightforward analysis. But as many of you know, when the rubber meets the road and you're really trying to evaluate these prior convictions, it can get a little complex. And so, Krista, I would like for you to kind of walk us through some of the complexities, some of the issues that might arise when you're looking at trying to determine whether a prior conviction is going to qualify as a crime of violence.
Well, it's absolutely true. There are some difficulties associated with this analysis of crime of violence. And the primary reason why there are some difficulties is because the court must consider two definitions of crime of violence in the application of the illegal reentry guideline. There is our definition of crime of violence under 2L1.2 that Rachel just discussed, and there's also a definition of crime of violence under the aggravated felony statute at Title 8, Section 1101A43. Now, the aggravated felony statute references Title 18, Section 16 for their definition of crime of violence. And so although these crimes of violence definitions are similar, they are not identical. And there's two significant differences. The first is under 2L1.2, our definition of crime of violence under the guidelines does not include the substantial risk of physical force against the person or property of another. The statutory definition for the purposes of aggravated felony does include this language, substantial risk of physical force against the person or property of another. Also in the statute under 8 U.S.C. 1101 A43, in order for a crime of violence to be considered an aggravated felony, there is the requirement that the prior conviction for that crime of violence must have received imprisonment for at least 1 year. There is not a requirement for sentence imposed for guideline purposes for the definition of crimes of violence. So first, the difficulty is that the court, of course, must assess whether the prior conviction meets the statutory definition of aggravated felony for the purposes of determining the statutory maximum for that particular case. And secondly, the court then, in their analysis under 2L1.2, must also then look at the guideline definition of crime of violence and determine whether that prior conviction meets our definition. So that extra layer of analysis sometimes adds some complexity in the courtroom. Let me also mention, Rachel referred to the fact, and we keep reiterating, that the aggravated felony statute and the guidelines definitions are separate components of the whole picture of the illegal reentry guideline. The only time for guideline purposes we're concerned about the definition of aggravated felony is for that 8-level increase under 2L1.2 B1C. Otherwise, for a 16-level increase, for a 12-level increase, we are not concerned with the definitions at aggravated felony. The guideline provides its own definition. Having said that, though, there are cases in which someone, a defendant, could receive an increase of 16 levels under 2L1.2 B1A for a particular prior conviction, but yet that prior conviction does not meet the statutory definitions of aggravated felony. And this has been difficult in some instances because the 20-year statutory maximum applies to aggravated felons, to people who have prior convictions for aggravated felonies. However, the 16-level increase is not directly tied to that greater statutory maximum. So that has brought forth some difficulties for some guidelines users. Let's take an example of this. A defendant has a prior conviction in, let's say, the state of Massachusetts for an aggravated for an aggravated assault. But the assault is a misdemeanor. It's punishable by a term of 2 years statutory maximum. The defendant in this prior conviction on this misdemeanor assault received a sentence of 1 year of probation. For guideline purposes, we are looking first at whether this prior conviction meets our definition of felony, which it does, because this prior misdemeanor assault is punishable by a term exceeding 1 year. The statutory maximum is 2 years. The second criteria we're concerned about for the purposes of 2L1.2 is whether this assault would meet our definition of a crime of violence. And after looking at the list of enumerated offenses and the second part of that definition, the court most likely would determine that an assault is a crime of violence. So this misdemeanor state assault, prior conviction, would receive an increase of 16 levels. However, this same prior conviction would not subject the defendant to a statutory maximum of 20 years because it is not an aggravated felony. And the reason that it is not an aggravated felony is because it is a crime of violence, but it is a term of imprisonment of 12 months, of 1 year, was not imposed. So it could not be considered an aggravated felony under the statute. So there are some instances where a 16-level increase will be applied to someone who is not convicted of a prior aggravated felony. And so that difficulty, I think we needed to address.
Absolutely, and again, a good illustration of the interplay between the statutory definitions and the guideline definitions, and how important it is to realize which are the guideline definitions and which are the statutory definitions, and when they impact each other and when they don't, because you may very well have a situation where, Just like you said, a defendant's getting a 16-level increase for a crime of violence that is not, by definition, an aggravated felony. And again, for those of you who have been dealing with this guideline for a number of years, I'm sure will remember when the guideline only provided a 16-level increase for any aggravated felony. So again, it's things that you have to continually keep in mind as you're dealing with determining types of prior convictions at 2L1.2. So thus far, we've talked about the categorical approach in relation to crimes of violence. But I also mentioned that the court needs to use the categorical approach in determining what is a drug trafficking offense. So let's take a little bit of time now to look at the guideline definition of drug trafficking offense. And as you can see, it's defined at 2L1.2 Application Note 1B4 as an offense under federal, state, or local law that prohibits the manufacture, import, export, distribution, or dispensing of a controlled substance, or possession of a controlled substance with the intent to do any of the above. Now, recent appellate case law, specifically in the Fifth and Ninth Circuits, has wrestled a lot with this particular definition. And that's because there are a lot of state statutes that can be somewhat confusing as to whether or not they're actually drug trafficking offenses if they have those elements that are required for the guideline definition. Certain prior convictions such as offer to sell or transportation have been held to not qualify as drug trafficking offenses in these circuits. So again, there's some difficulty that can arise when trying to determine whether a prior conviction is a drug trafficking offense.
And let me point out here that the offer to sell and the transportation, I'm sure, looked very much like drug trafficking offenses. However, it's because of the categorical approach and the limitations on the documents that the court may look to that perhaps have kept these particular prior convictions out of qualifying for the definition under the guidelines for drug trafficking offenses. So it wasn't clear from the documents in offer to sell or in transportation offenses whether they did specifically meet the drug trafficking offense definition that Rachel just reviewed. So again, this categorical approach is really important, very crucial for the courts to consider when looking through this guideline.
Now, when Krista walked us through the increases at the specific offense characteristics at 2L1.2, she made a distinction between drug trafficking offenses in that some drug trafficking offenses will warrant a 16-level increase while others will warrant a 12-level increase. It's important to point out that the reason why is because drug trafficking offenses are the only prior convictions for which we're concerned about the sentence that was imposed. Being if the sentence imposed was greater than 13 months, that would warrant the 16-level increase. If the sentence imposed was 13 months or less, that would only warrant a 12-level increase. So it's important to keep that distinction in mind. And of course, anytime you're looking at what sort of sentence was imposed, there are issues that can arise. One of the issues that comes up when determining what the sentence imposed is, what if there's a portion or all of that sentence that was suspended? Well, the guideline specifically directs at Application Note 1B7 not to include any portion of a sentence of imprisonment that was probated, suspended, deferred, or stayed. Now again, just to reiterate that the statutory definitions have their place and the guideline definitions have their place, this does not in any way affect the statutory definition of what is an aggravated felony. One of the other issues that can arise when looking at sentence imposed is the issue of what if there was any time imposed upon revocation? Well, the application notes at 2L1.2 very clearly direct the courts that prior revocation time is added to the original term of imprisonment in order to determine what the sentence imposed is. And this is consistent with what we do at our criminal history rules at 4A1.1. And as you can see, there are several circuits, the 2nd, the 5th, and the 9th, who support this notion of adding any revocation time to the term of original imprisonment that was imposed. One of the last things I want to talk about in one of the issues that comes up in determining sentence imposed is what to do in the case of an indeterminate sentence. And again, the guidelines clearly guide the courts in the application notes, specifically at 1B7, to use the length of this in a prior indeterminate sentence to use what the stated maximum is. And again, you can see the Eighth Circuit has some case law in support of this. In other words, if you have a prior drug trafficking offense for which the sentence imposed was 1 to 3 years, that's an important distinction between whether that might be a 12 or a 16 level increase. And since the application notes clearly say you're going to use the stated maximum, you would look at that as being a 3-year sentence, therefore warranting a 16 level increase for that drug trafficking offense.
Now, before we leave the topic of drug trafficking, I would like to mention here a recent Supreme Court case. Now, Rachel, you've been talking about drug trafficking offenses that would warrant a 16 level increase or a 12 level increase.
Right.
What I'm going to talk about actually has nothing to do with the 16 level increase or the 12 level increase, but it does have to do with the definition of aggravated felony, the 8 level increase. The Supreme Court decided in Lopez versus Gonzalez, what they addressed in this case was the simple possession of a controlled substance in the context of the definition of aggravated felony. Now, in the Lopez case, the Supreme Court rejected the view of the majority of circuit courts and held that a state drug offense of simple possession constitutes an aggravated felony under Title 8, Section 1101, A43B, only if the offense prescribes conduct that is punishable as a felony under the Controlled Substances Act. The fact that what was happening were there are state offenses for simple possession that are classified as felonies. The courts were holding that those state felony simple possession convictions were aggravated felonies. What the Supreme Court decided in the Lopez versus Gonzalez case was that the fact that a state classifies a particular possession offense as a felony is not sufficient to qualify it as an aggravated felony. The Supreme Court said that in order for a state offense to be classified as an aggravated felony, it had to meet the federal definition that is listed under 1101 A43B in the context of illicit trafficking. So as a result, for the most part, then, simple possession offenses will not qualify as aggravated felonies. Okay, we've talked about the definition of crime of violence in the statute as well as in the guidelines. We've talked about the definition of drug trafficking offenses in the statute and in the guidelines. We've talked about the categorical approach and how important it is for all of those analyses that are required for those definitions. There are, of course, these other categories of offenses that we mentioned at the beginning of the broadcast. You saw the laundry list of the particular types of crimes that would qualify for a 16-level increase under 2L1.2B1A. And these offenses include prior convictions such as child pornography, firearms offenses, human trafficking, alien smuggling offenses. And the definitions for those particular categories, of course, are also included in the application notes at 2L1.2. We're not going to go into each of those individually today, however. We were focusing primarily on the areas that have generated the most litigation, which are crimes of violence and drug trafficking offenses. But these definitions, let me point out, refer to federal definitions and generally have not generated as much litigation. So if you have any particular questions about those categories, you can always call us on the helpline or feel free to fax us in a question. I was just going to say there's a couple of other issues that we need to touch on before we go to the smuggling guideline. And this topic is something that you and Alan talked about in your previous broadcast about relevant conduct, and that is the interplay between Chapter 4, criminal history, and Chapter 2, calculating the offense level. And we've obviously been talking about how prior convictions are the thing we're looking at under 2L1.2 in order to determine the offense level. So let's talk a little bit about how criminal history interacts with the prior convictions in Chapters 2 and 4.
It's important to know how they interact because clearly you're looking at prior convictions, and that's what we've been spending all this time talking about is looking at prior convictions to enhance the defendant's offense level at 2L1.1. And so it sort of begs the question of, well, then how does that impact, if at all, criminal history? Probably the most important thing to remember when you're applying the guideline at 2L1.2 and looking at these prior convictions is that there's no requirement that a prior conviction at 2L1.2 must receive criminal history points under 4A1.1. So it follows that the time frames that are applicable at 4A1.2, which is where we define how you score prior convictions at 4A1.1, are not applicable under 2L1.2. In other words, you can look at a prior conviction and enhance a defendant's offense level at 2L1.2 that would not qualify for points for criminal history purposes. In other words, we don't care how old those prior convictions are. And it really follows with how the statute is set up at 8 U.S.C. 1326, in that there's no time frames required to establish those enhanced statutory maximums based on prior felonies, be they aggravated or just prior felonies. So it follows that you can use that same logic in looking at prior convictions to enhance the offense level for the defendant at 2L1.2. So you may have a prior conviction for robbery or murder that may be 25 or 30 years old, and that could impact the defendant's offense level at 2L1.2, but it wouldn't be counted for purposes of criminal history. However, the application notes also clearly say that if they meet the definitions at 4A1.1 and fall within the time frames, then they are to be counted for purposes of criminal history. So if they're not too old, you count them to increase the defendant's offense level, and you give them criminal history points. Juvenile adjudications, however, cannot be used to increase the defendant's offense level at 2L1.2. This was a decision made by the Commission that they would not be looking at juvenile adjudications to increase the defendant's offense level at 2L1.2. But again, remember, if the juvenile adjudications aren't too old to be counted for purposes of criminal history, then you would include them in the calculation of the defendant's criminal history score. Please remember, as we're going through today, if you have any questions, fax in those questions. We'll try to get to them today. Any of those questions that we don't get to, again, you can always call us on our helpline, or we can get back with you after the broadcast and answer your questions. We really do want to help you. So we've talked about 2L1.2 at great length and some of the issues that arise when applying that guideline. We've talked about the interplay between prior convictions at 2L1.2 and criminal history. And we did promise you at the beginning of this broadcast that we would touch on the smuggling guideline at 2L1.1. So having said that, I'm going to hand it off to Krista to start us on the discussion of 2L1.1.
Sure. There are a couple of discrete issues we'd like to talk with you about today regarding the smuggling guideline. Now, this guideline is 2L1.1. It addresses the smuggling, transportation, or harboring of an unlawful alien. And it addresses violations of Title 8, Sections 1324 and 1327. The guideline provides alternative base offense levels. There was a new base offense level at subsection A1, which provides a level 25, and this was recently added to the guidelines effective November 1st, 2006. This base offense level was added to address the smuggling, harboring, and transportation of aliens who pose national security concerns. What's important to remember about this base offense level is that it applies only if the defendant was convicted under the particular statute at Title 8, Section 1327, and the violation involved an alien who was inadmissible as defined under Title 8, Section 1182A3. And so that was added, as I said, to address national security and terrorism concerns, but it only applies for offenses for a defendant convicted of a particular offense. It is not relevant conduct based. However, I do want to talk a little bit about relevant conduct for this guideline, 2L1.1. In your prior broadcast with Alan, Rachel, you talked about offenses for which expanded relevant conduct would apply. And the criteria for that would be that the guideline is listed as groupable under 3D 1.2D. The smuggling guideline, 2L1.1, is listed at that provision. It is listed as groupable under 3D1.2d, and therefore this guideline is subject to expanded relevant conduct, which is found at 1B1.3A2. Now what this means is that in calculating the offense level for a smuggling offense, the court can look to conduct that is the same course of conduct or common scheme or plan as the offense of conviction. Now, one specific offense characteristic that is particularly affected by this analysis is specific offense characteristic B2. This characteristic provides a table with increases of 3, 6, or 9 levels depending upon the number of unlawful aliens that were smuggled, transported, or harbored. If the offense of conviction is limited to the 4 aliens that were brought in on one occasion, however, the defendant has other conduct that is the same course of conduct or common scheme or plan involving the smuggling of 20 additional aliens, the court could look to including those 20 additional aliens, of course, as long as it meets the standards of relevant conduct at 1B1.3. Another specific offense characteristic that greatly comes into play under the 2L1.1 guideline is specific offense characteristic B6. Now, this characteristic provides a 2-level increase and a floor offense level of 18 if the offense involved intentionally or recklessly creating a substantial risk of death or bodily injury to another. Now, this characteristic has been the subject of some litigation regarding the interpretation of whether particular circumstances of an offense constitute substantial risk. Now, the guidelines in Application Note 6 provide some examples of conduct to which this specific offense characteristic would apply. And this note directs that the increase applies to a wide variety of conduct, including transportations of aliens in the trunks of vehicles, in the engine compartment of vehicles, or carrying substantially more passengers than the capacity of the vehicle, than is authorized by the capacity of the vehicle. We have heard from a number of folks that substantial risk, this specific offense characteristic, can apply in situations where aliens are being smuggled in a van, and the van contains 10 seat belts, but there are 15 aliens. Because there are not enough seat belts for all of the unlawful aliens being smuggled, this substantial risk increase has been applied. So it does apply to a wide variety of conduct, but I would caution you to look to your case law. There are a lot of decisions, especially in the 5th and 9th Circuit, that interpret this specific offense characteristic, and so I would encourage you to look there if you have any questions about substantial risk. Another specific offense characteristic regards the increase for the death of a victim or of an unlawful alien, or the degree of injury that was suffered by a participant in the offense. The specific offense characteristic says if any person died or sustained bodily injury, the court is to increase the offense level according to the seriousness of that injury. And you can see the table provides an increase of 2, 4, 6, or 10 levels in cases that involve the death of an unlawful alien. Now, the Commission increased from 8 to 10 levels that subsection addressing the death of an alien. That was amended November 1st of 2006. I'd also like to note that application of this particular specific offense characteristic does not require that the injury or death be intended. And you can see the Garcia Guerrero case on your screen now. That states that there is a strict liability standard, that the injury or death does not need to be intended for this specific offense characteristic to apply. And so that generally and quickly is a discussion of the Smuggling, Harboring, and Transportation Guideline under 2L1.1. So we've covered a lot of information so far today. We do have some faxes that have come in prior to the broadcast that we'd like to address, and of course we encourage you to continue to fax in your questions so that we could address them.
Okay. The first one I want to ask you about, Krista, is actually one that we got earlier, not earlier today, but a couple of weeks ago, from the Eastern District of Pennsylvania. And the issue here is, at what point does a violation of 8 U.S.C. 1326 actually occur? Does it occur when the defendant initially enters the United States, or does it occur when the defendant is found in the United States? And depending on what the answer to that is, how does that, if at all, affect criminal history in the application of the guidelines for these offenses?
Well, it's a good question, and it often comes into play with illegal reentry cases. And that is usually because the alien unlawfully enters at one point, but the alien isn't discovered to be here illegally until they are found at a later date. Usually it's because of additional criminal conduct, that the alien is arrested, they do the background check on the alien and find out, okay, this person is here illegally, even though the defendant entered a number of months ago. And it does have implications for criminal history purposes, because it really becomes a question about relevant conduct, and also a question about the term continuing offense. In this area, in 2L1.2, for cases involving illegally being found in the United States or illegally entering the United States, there is a body of case law that defines these crimes as continuing offenses. And so I would suggest for the people from the Eastern District of Pennsylvania to look to that case law for instruction on how to define something as a continuing offense. But of course, for the purposes of relevant conduct, we are looking at a preponderance standard. And I think there can be a decision made that even though the person is found illegally in the United States, let's say in May of a particular year, but there's a preponderance of the evidence that the person had illegally entered the United States in January, a few months before they were illegally found, I think the relevant conduct date would start from then.
Right. And Krista, you did mention that it's a case law driven issue, and there is a lot of case law out there on this point. I know the person that submitted the questions from the Eastern District of Pennsylvania, and it's possible that there's not a whole lot of case law in his circuit, but I know after having trained out in the Ninth Circuit and the Fifth Circuit that there is a lot of case law in those circuits that would address this issue. And so the caller may want to look to those cases for some sort of guidance on how to give his court, how to deal with these types of offenses. We got a couple of questions from the Southern District of Texas that deal with really kind of suggestions, or I don't know if suggestions would be the right questions. Are you going to address this specific aspect of immigration offenses at some point in 2L1.2? One of them being this issue of substantial risk that you talked about. Would you give guidance in the application notes in regards to aliens traveling within the United States on foot? Another one of the issues that the Southern District of Texas brings up is this issue of aliens who have 10 or more prior removals, whether they be voluntary or not, before they actually get convicted of illegal reentry. And is there any envisioning on the part of the Commission to provide specific guidance in either a specific offense characteristic for an increase or an upward departure that would be appropriate or encouraged in these types of cases? So Krista, what are your thoughts as being chair of the immigration team on where the Commission may be going with some of these suggestions?
Well, interestingly, the Commission is at the beginning of its amendment cycle, and the Commission identified as one of its final priorities for this amendment cycle immigration offenses, both the illegal reentry under 2L1.2 and alien smuggling under 2L1.1. So all suggestions or concerns that you in the field as guidelines users may have, the Commission would love to hear about. So please send us your comments. There will be an appropriate time in late December, early January, where the Commission will publish particular guideline language or issues that they are thinking about addressing during this particular amendment cycle. So I would encourage you to submit to the Commission formal comment regarding those issues. Obviously, we will be taking back this information that you've given us today regarding your concerns about frequent removals, multiple removals, prior to finally having a criminal conviction for illegal reentry. And also your issue about substantial risk. So I will put that in my in the bank of knowledge we keep at the Commission regarding concerns and suggestions that you have. But please, if you do have comments about the immigration guidelines, please submit them to the Commission when you can.
One of the other issues that comes up, and this goes back to the categorical approach that we have talked so much about this afternoon, and that is the issue of prior conviction and applying the categorical approach. And let's say we have a defendant who has a prior conviction for assault on a public servant that is a state felony, punishable by up to 3 years of incarceration. The defendant was sentenced on that to 6 months imprisonment. And the elements of the statute of conviction include intentionally, knowingly, or recklessly committing bodily injury against a public servant. What are, Krista, if you can, again, using the categorical approach, walk us through the steps that we would need to take to determine whether or not this prior conviction for assault on a public servant would qualify as a crime of violence at 2L1.2?
Well, first of all, we would be looking at the fact of the prior conviction, which we have, and the elements of the statute. So we're looking at the statute of conviction. I believe you said it was knowingly, recklessly, or intentionally causing bodily injury on this officer. And so the court will need to look to, using the appropriate documents for support, the guideline definition of crime of violence in order to determine whether this assault meets the definition. Now, included in the elements of this prior conviction are knowingly, intentionally, and recklessly. Knowingly or intentionally causing bodily injury would obviously qualify as a crime of violence because it involves the use, attempted use, or threatened use of physical force against the person of another. Recklessly may not quite meet that definition. So the court will then have to look to the other judicially noticed documents that are involved or that are a record of this prior conviction in order to assure or make sure that the prior conviction involves the intentional or knowing causing of this bodily injury. So the court will be limited to looking at those particular documents, but would have to determine, of course, whether it meets that crime of violence definition using that categorical approach analysis.
And you touched on the issue of the fact that there are 3 separate elements for this prior conviction. And I think some folks can get confused in that, well, it's got 2 elements that very clearly would be the use, threatened use or attempted use of physical force against the person of another. But the reason why you have to go on to look at the documents is because there is that 3rd element of recklessly committing bodily injury, which would not have as an element the use, attempted use, or threatened use of physical force against the person of another. So because it has that element and you don't know what the defendant's been convicted of, you have to then look at the documents that you've talked about to determine whether or not it's going to meet the definition of a crime of violence.
That's right. And so the answer would be different depending on what's in those documents. If the charging document omits reckless from those papers, it very well could be that the court would say, okay, that is a crime of violence. But if recklessly is included, the court obviously is not going to look there.
Right. Well, I think that we've got one more here from the Southern District of Texas. We've got a first-degree, it's a prior conviction for a first-degree burglary in California that does not qualify as a crime of violence for the 16-level increase at 2L1.2 as the enumerated offense of burglary because the California state statute does require unlawful or unprivileged entry, though it does not require with intent to commit larceny or any felony. Okay. As such, the question is now, would this burglary conviction then qualify as an aggravated felony at 8-1101-A43G as a theft offense? And I mentioned earlier that, there's a laundry list of offenses at the aggravated felony definition at the statute that are considered aggravated felonies, and I mentioned certain theft offenses. So, Krista, what's your thoughts on this particular?
Well, and the analysis, we're repeating the same analysis over and over again, but the analysis is obviously the categorical approach analysis. What the court will have to do in this situation is look at the fact of the prior conviction, look at the elements of the statute of conviction, and determine if, categorically, if that prior burglary conviction meets the definition at aggravated felony. So the court would need to determine if it is a theft conviction. And I believe that for theft offenses, there's a requirement of sentence imposed. I'm not sure on that, but
I think you're right on that
obviously
one.
you need
I
to
think you're right.
look at the statute there. But so there's two things I think the court would need to consider. But the fact of the prior conviction, the elements of the statute of conviction, and then any supporting documents that the court would need to clarify whether this prior conviction meets that particular definition. So the answer is the categorical approach.
Right. And again, within the context of the statutory definition of aggravated felony, because that's what we're looking at here, statutory definition of aggravated felony, because the decision's been made, and it's not going to meet the guideline definition of crime of violence. So again, keeping those guideline and statutory definitions separate, categorical approach would relate back to what the statutory definition of aggravated felony is for theft offenses.
That's exactly right. That's right.
Okay, that covers it for the questions that we've gotten. We hopeful that we have responded to your questions in a fashion that is satisfactory to you. Again, if we haven't, please call us on our helpline at 202-502-4545, and we'll be happy to expand or answer any other questions you may have. And with that, I'm going to let Krista close us out this afternoon.
Well, and I would thank you all for watching us today, of course, and I would encourage you to join Rachel and I. We will be on TV live again on November the 8th, and our next broadcast is called Sentencing and Guidelines 2007 Amendments. So the broadcast on November the 8th will be discussing the new amendments to the sentencing guidelines, which, barring congressional action, will become effective November 1st of 2007. So we hope that you can join us then. But otherwise, thanks for watching today. Thanks for your faxes, and we look forward to seeing you soon.
Thanks, and have a great day.